it will be easier, less expensive for the seller itself to collect the information required to engage in cross-border transactions, to sell its goods abroad, in fact. And this will encourage sellers based in the EU, sellers based in a member state of the EU, to expand their business beyond the boundaries of their own state and engage in transactions with a cross-border element. If things were otherwise, there would be distortions in competitions, because a rule whereby, for example, the buyer's habitual residence were the connecting factor would imply that sellers in different member states would be disproportionately affected by the transaction costs involved by the collection of information regarding foreign law when foreign law applies. So sellers based in large countries with a significant internal demand would be, so to say, benefited from this strange rule, whereas sellers in a small country will have to face more important transaction costs. And this would, in the end, run counter the goals of regional integration and would frustrate the concerns for the proper functioning of the internal market. So what I would like to say with the slides is that the choice of connecting factors and the design of connecting factors in private international law rests on a political idea, on policies, and geography is just the way in which, the peculiar, strange way in which those substantive policies are translated into a rule. Next slide, please. Situations exist where the policies underlying a private international law rule warrant the use of not one but several connecting factors. What to do in these cases? What happens if the connections of the situations are multiple? How to deal with these situations? There is another example I would like to provide to show you the way in which EU law addresses this challenge. It's in the field of family law, so it's very far from what we're talking about today, but it's just an example of methodology. There is a regulation which is the Brussels II bis regulation, now the Brussels II bis recast regulation, which governs, among other things, jurisdiction in parental responsibility matters. Now, under this regulation, in particular, pursuant to Article 7 of this regulation, when it comes to children protection of children, the courts with the jurisdiction are the courts of the habitual residence of the child. So one connecting factor. But if the concern is to provide children with appropriate protection, well, it might be that in the particular circumstances of the cases, other courts of a country other than the courts of habitual residence of the child, might be better placed to address the matter. So it makes sense, and the regulation reflects this, it makes sense to provide that these other courts of a country other than the country of habitual residence, might have a say on the protection of the child. So how to deal with this potential positive conflict of jurisdiction, having several courts entitled to hear the case? Well, there is a very interesting solution which is provided by Article 12 of this very same regulation. It's the possibility for the courts of one member state, the courts of the habitual residence of the child, to transfer the case to the courts of another member state on the assumption that the latter are better placed than the former to deal with the particular case at issue in the circumstances. I will get back to the logic of this approach in the conclusions of my presentation, which will be in very few minutes now. Now, next slide, please. I would like to mention the fact that in this situation where policies matter a lot and geography, the geography of private international law is merely instrumental to the realization of policies, connecting factors, the importance of connecting factors tends to fade to some extent. And I have an example to provide you with. It's the historical evolution of the rules on the recognition of judgments in Europe. I mentioned, as you can see in the slide, the geology in this field because the evolution is peculiar in this field. There are old rules which are still in place. There are newer rules which have seen the light of the day. And there are even more recent rules, and all of these coexist. So you can see layers in this area of law, different layers of logic, of approaches. They coexist. Now, the old approach to the recognition of foreign judgment is expressed in the so-called mirror image rule. The idea is that a judgment is recognized, a foreign judgment is recognized only if it comes from the correct country. The correct country is the country whose courts have jurisdiction based on the rules on jurisdiction of the requested state. So the requested state will only accept such foreign judgments as come from courts which have jurisdiction based on its own rules, the mirror image rule. Now, this old way of approaching the recognition of judgments is very much based on geography. Connecting factors matter, are decisive for the recognition of judgments. There is a newer approach which was first adopted in 1968 with the 1968 Brussels Convention on the recognition of judgments. And it's the idea that connecting factors should matter less, provided that the states concerned, so the state of origin and the state requested, the state where the effects of the judgments are relied upon, share the same views on some rules, have in common some provisions, in particular some provisions on jurisdiction. So the very Brussels Convention of 1968, which is today the Brussels 1 bis regulation, provides that recognition of judgments emanating from a member state do not require any check as to the jurisdiction of the courts having rendered the judgment in question. But it does so on the assumption that all member states use the same rules on jurisdiction, the rules on jurisdiction harmonized by the Brussels Convention and today under the Brussels 1 bis regulation. So harmonization of jurisdictional rules creates trust, and trust prompts recognition, no matter the origin, no matter a check on the origin of the particular judgment in question. Harmonization as a factor of trust is used in other pieces of EU private international law as far as maintenance obligations, so child support or spousal support. There is a set of EU rules which put it shortly, provide that recognition of judgments is easy when harmonization of not only jurisdictional rules, but also rules on applicable law exist. And if the rules of civil procedure, some rules of civil procedure have been harmonized, that too works as a factor of trust and provides for an easy circulation of judgments, regardless of any check as to the origin of the judgment itself. Final stage of this geology, of this evolution, there are regulations in the field of private international law where the recognition of judgments is granted no matter the origin of the judgment and no matter the harmonization. So there is a regulation, it's Regulation 606 of 2013, which is about protection measures against domestic violence, for example. It's not criminal law, it's a civil law. And the idea is that if one such measure has been granted in the member state, the effects of that measure can be relied upon in other member states without the need of determining whether the courts which render that judgment were the right courts, and regardless of any harmonization in this field. Next and final slide, please. Thank you. All right, so some concluding remarks. What comes out from this very rapid survey of EU private international law is that geography is still important in the language of EU private international law, but what matters really is geography used for governance purposes. So it's not really a question of territoriality. Sovereignty is not really involved. It's rather sovereignty. It's rather governance, the governance of shared concerns, common concerns, concerns shared by the member states of the European Union when it comes to EU private international law. The policies behind the concerned areas of private law, or the policies behind the creation of an internal market or an area of freedom, security, and justice shape the design of connecting factors and shape the way in which several connecting factors combined and more radically shape the extent to which geographical connections still matter in this field. So where strong policies exist, common to the states in question, as it is the case within the European Union, connecting factors are just one of the various techniques that may be used to govern transnational phenomena. They may be designed in such a way as to advance those policies, or may be disregarded altogether when those policies may be served in another way. So in the end, the message I would like to convey, private international law very much uses connecting factors, but uses connecting factors for instrumental reasons, for reasons that have to do not with private international law itself, but with more general policies of a substantive, procedural, or regional integration nature. Thank you.